Hello there. This is JJ Minioza. I'm a shareholder with the Oakland East Bay office of Ericksen, Arbuthnot, a California law firm. And today we're going to talk about the strategic use of CCP Section 998 offers in habitability cases. Now, attorney's fees, for those of you who regularly handle these types of claims, attorney's fees are often the driving force in habitability cases, very similar to what we see in employment cases. And oftentimes the amount or claim of the attorney's fees is often far greater than the amount of damages that are potentially recoverable in the case. And the other issue that we often see is that the attorney's fees claim is not covered by our client's general liability insurance policy or any other insurance policy, which creates a personal exposure to our clients that often is much more significant than the covered portion of the exposure, i.e. the damages. Now, in habitability cases, there are different ways to recover attorney's fees through a tenant protection ordinance, such as you see in larger cities like Los Angeles, Oakland, or San Francisco, the California Civil Code, specifically Section 1941 et sect, or an applicable attorney's fees provision in a lease. Now, we use strategically an early CCP 998 offer to the plaintiff as a way to potentially cap our client's attorney's fees exposure. But for the 998 offer to have a strategic effect, they need to be served early before the plaintiff's attorney's fees become too high. And one thing we should always remember when defending habitability cases is everything we do that we typically do to defend a case, for example, written discovery, taking depositions, everything we do also increases the attorney's fees on the other side. So again, serving the 998 offer early strategically makes sense rather than as you get closer to an approach trial, which at that point, their attorney's fees are much more significant than early on in the case. Now, to be effective, the language in the 998 offer has to be different than what we typically use when serving these offers in other types of cases. The typical language states in each offer, quote, each side is to bear their own attorney's fees and costs. That's the typical language. But in a 998 offer, to be effective in a habitability case, it has to have language that says that the offer is, quote unquote, inclusive of attorney's fees. And the language that we use typically reads similar to this. Plaintiff is to recover attorney's fees and costs up to a certain amount, and the amount is capped at a maximum, for example, $5,000. So the offer can be a total of $15,000. $10,000 are allotted to damages, and $5,000 are specifically allotted to attorney's fees and capped at that amount. Again, strategically, when we serve these 998 offers, they often have a benefit of causing the other side to start negotiating early, which benefits our clients by reducing or stopping their potential exposure, especially to non-covered claims for attorney's fees. But one con that we often see is it sets a floor for mediation. So coming right out of the gate with an offer is something that you can't ever get back, and again sets a floor for mediation, and you'd have to negotiate from that point forward. And again, the significance of the early 998 offer is that it's to be done early before the plaintiff's fees become so high that the 998 offer no longer becomes workable. And this gives us a basis to argue to the court that if the plaintiff does not recover damages in an amount greater than the 998 offer, then we can argue in a post-trial motion to the judge that the plaintiff can't recover their post-offer attorney's fees, only recovering their pre-offer attorney's fees. Again, underlying the significance of making this offer early.